So I'm here to talk a little bit about the implementation of a new resentencing law that was passed in Minnesota last year. But as Pooja mentioned, For the People was very helpful to us also in getting the law passed. They analyzed data of the people who were in prison in Minnesota, and we're able to show our legislators, who's in prison in Minnesota, what are other states doing, what's going on across the country. Very persuasive and very helpful. And now we're very lucky to have them helping us as we start to implement this new law. Next slide, Pooja, please. So of course the question is why resentence, and Pooja touched on that. Some of the handouts that Chris provided are also got a lot of really helpful information about it. But having been a prosecutor for 30 years or so, these are some of the reasons that jumped out at me. Next slide. We know what we know and understand about society in general, and criminality changes and develops over time. So, one of the things that popped into my mind was that um, I started prosecuting 30 years ago. The lawyers and prosecutors who were the generation ahead of me, who trained me in and mentored me, and who were what I wanted to be like when I became more experienced, they were among the first prosecutors to prosecute child abuse cases in our state and in our country. And it's weird to think about child abuse prosecution as a new thing, but back in the 1980s, it was. And so that's an example of something that was not criminal becoming criminalized, but we now have the reverse happening with marijuana, right? Many states are changing their laws as to marijuana. We also have a different understanding about the development of youth brains and what youth understand as they make decisions relating to delinquent and criminal matters. So what we know and what we understand about situations, what we value about situations, changes over time, and makes it important, I think, as ministers of justice to go back and look at some of the convictions that we have. Next slide. We also know that there can be disparities. So we've all prosecuted uh, groups of people for committing an offense, and we know within the group some people are more culpable than others. And I think all of us have heard horror stories of those people who were lesser involved somehow getting longer sentences than the people who were more significantly involved. Maybe it's a difference of attorney, maybe it's a different sentencing judge, but some really troubling disparities can occur. This is an opportunity to adjust those. There also can be disparities in sentences geographically. So in Minnesota, we have the Twin Cities of Minneapolis and St. Paul. In an urban area, we tend to, for example, certify youth as adults when they commit very, very serious offenses, murder, really violent sexual assaults. Years ago, when I was a newer prosecutor in outstate Minnesota and our beautiful 10,000 lakes, those counties were prosecuting youth as adults for burglarizing cabins. So that's a disparity in how cases are handled and how they are sentenced. Next slide. And of course, as Pooja has mentioned, we know that people change, and the individuals who are the subjects of our sentences may rehabilitate, or there may be things about them that just make them less as a public safety risk, and those longer sentences no longer serve justice. Next. And I wanted to add this slide just to highlight the fact that resentencing is not the same as reviewing a wrongful conviction or a claim of innocence. So looking at resentencing is to address unfair sentences, unnecessary sentences, not necessarily sentences that involved innocence or something going wrong at the time, but more as things have changed over time, we look at the situation differently. Next. So Minnesota passed a law last year about this time. It went into effect August 1st of 2023. As Pooja mentioned, this one puts the prosecutor in the driver's seat. And we can recommend an adjustment in sentencing as long as we do not increase the period of confinement or supervision. Next slide. it Minnesota law is very clear. There's some great language in it that the prosecutor is the initiator of this offense. There are people in the statute who may request us to review sentences. The Commissioner of Corrections, the probation officer that supervises the person, and the convicted person may request review, but our statute is very clear that we are not even required to respond to those requests. And any inaction that we take is not the grounds for someone else to pick up the ball and file a petition in court to adjust a sentence. So very important piece for us in establishing this legislation. Next. So then once we identify a case, then the statute is very prescriptive about what should be in the petition. And there really are quite a few requirements. Some are what you would expect, of course, criminal history and why you want to resentence and what this person has done to rehabilitate. Next. But some of the elements are not so intuitive, and I think they really show the thoughtfulness of the statute. So between the person with the conviction and the victim, is there a protective order in place, or has there ever been one? If so, the court wants to know about that, I think, as a measure of, how violent has this person been, or might they be? They want to know about any charges brought against this individual, including charges that were eventually dismissed or diverted. And any request that this individual has made on any offense for expungement, for pardon, for exoneration, whether or not it was granted, the court wants to know about it. So next. And then the statute has some really great language for victims. So, of course, prior to filing the petition, we're required to make an effort to seek input from the victims. But then the statute says, and shall consider the impact the adjusted sentence would have on the victim. I know that that's something that might on its face not seem like a lot of teeth, just requiring us to consider it, but I've never seen language like that in a statute. And I think the fact that it is there speaks volumes. We are also required to notify victims once we file the petition and let them know that they have a right to be at the hearing and be heard at the hearing, either orally or in writing, and that if they come or if they are not able to attend and they object to the resentencing, it is our duty to make sure that the court knows that. I've heard that in different areas around the country that victims groups or victims have felt like they've been left out of the legislative process. For our law, 2 different victims groups testified in favor of the law, which was very helpful in having the law passed and meant a lot to us to have their support. Next. So the court then, once a petition is filed, holds a hearing, and under our law, prosecutors and defense attorneys can make written arguments before the hearing and then make oral arguments at the hearing. We can call witnesses who have relevant information to share, and then victims, of course, have a right to give input either orally or in writing. And then again, we've got this really, I think, meaningful language that says the judge shall consider the victim's statement when making a decision. I think that will really help us make sure that they get heard. And again, the fact that that language is there speaks volumes. Next slide. The burden of proof, I should have adjusted my slide a little bit. The burden of proof is actually a preponderance of the evidence. And the court needs to decide whether there are substantial and compelling reasons to adjust the sentence. They need to consider, of course, public safety. Would the sentence have a rehabilitating effect on the individual? Does it properly reflect the severity of what happened? And a big value, does it work to reduce sentencing disparities? Next. The court can review several documents. I take it that it is our responsibility as the petitioner to supply those, but the court can review pre-sentence investigation reports, information if the person has ever been on supervised probation, how they did, disciplinary records from when they were incarcerated, and of course, records of rehabilitation. And then as Pooja and Chris's question got at, evidence of age or remorse or, sickness, maybe even something that might diminish the likelihood that they will recidivate, all relevant. And we can also argue that changes in law and sentencing practices have changed and developed over time and are relevant to this consideration. Our statute specifically allows that. Next. And then the court can modify the sentence as long as it does not increase the period of confinement or supervision, as long as it does not reduce or eliminate court-ordered restitution or change a mandated conditional release term. Next. So once the law passed, our office then tried to identify some of the key things that we needed to do to get ready to implement this statute. And I must say that we had a very productive legislative session in Minnesota last year, and several different reform acts passed, including a felony murder reform act, several reforms as to how people who were convicted of sentences when they were under 18 are given parole, and many other things. Many of the other reforms had some key deadlines that we needed to work to meet. Prosecutor-initiated sentencing is at our discretion, and so unfortunately it got a little bit lower of a priority, and we're still in the starting up stage and finding our way stage. But these are some really key things that we know we want to work on and develop as we get ready to go. Next. So the first one is a review of data. And again, here's where For the People were just tremendous help. Just as they had showed our legislature who's in Minnesota in prison, they were able to work with us to take a really careful look at who is in prison on Ramsey County convictions, and what do we need to know about them. And they helped then by presenting this information to our community advisory board, which I'll talk about in a minute. Next slide. But a little bit more about the data. So they started with the basic, demographic information, including how old was this person at the time of the offense? How old are they now? They added that key sentencing information. Is this a life sentence? Is it with or without parole? Or if it's a guideline sentence, what is the guidelines? And then they added different possible categories about the length of time served, looking at people that have served 5 to 10 years, looking at people that have served more than 20. Added in, why is this person in prison? Are they there because of a new conviction? Are they there because they violated parole because of a new conviction? Or are they there because they violated parole for some other reason? Very helpful things to know that you might not think about when you're just starting in on this. They added categories of cases and then specific offenses. Next slide. And then this ended up then they folded some of this information together to show us different possibilities. So how many people did we have who were 18 to 21 years of age at the time of the offense who have served at least 15 years? Or how many people do we have who were convicted of non-criminal sexual conduct, non-homicide offenses who are at least 55 and have served 10 more years? So you can see how helpful it is to put all that together and get a snapshot of some different possibilities and areas to prioritize. Next. And so once they, were able to pull that data together for us, our county attorney, knowing that prosecutor-initiated resentencing was important to the community that we served, decided to establish a community advisory board to advise him on the priorities of cases that we might approach first and different procedures. But one important clarifying thing was that the advisory board was not to weigh in on specific cases. So our board meets quarterly, usually in the early evening hours, and we provide a dinner. The county attorney, we all kind of submitted some ideas for different people, and the county attorney reached out and recruited people personally and explained his vision and invited them then to be part of our board. And our board has just a really great cross-section of different perspectives that are really helpful to our decision-making process. So we've got some formerly incarcerated individuals. We've got people who are leaders in victim advocacy, leaders in law enforcement, leaders in corrections, some law professors, some people who are head of the equity programs in their organizations. And then we've got 2 faith community leaders, one of a rather conservative type, and one much more progressive. But there's 11 of them total. And again, their role is to advise us about the priorities of cases to start in on, and a little bit about procedures. Next. So in terms of those procedures, our heads were kind of spinning as we thought about process and approach. As you maybe can tell from what we've said about the Minnesota law, it's very much prosecutor initiated. Almost don't call us, we'll call you situation. But what about applications? Should we accept those? Should we develop one? What if we decide not to, and individuals reach out and make requests? We want to be ready for that. So I don't think that there's a right decision for any one jurisdiction. I think everybody has their own needs, their own laws. Jurisdictions that have had three strikes laws may make different decisions than others. But we made the decision that at this time, I mean, we were partly worried about being flooded, and we did not want to accept applications. And so when people do send us things and write letters making requests, we scan those into the file, we code the file so that we can run a report and identify them. And then as we're looking in cases that we've selected and for the people is helping us analyze, we can see, oh, this person has also made a request. Interestingly, a county near us is using an application form. And so yesterday, for the first time, we got a packet from an individual in prison who had taken the other county's form, crossed off their county name, wrote in Ramsey, and filled out the forms and submitted it. So, that was great. We've actually got a signed release for this person at this point. We scanned it in, and he doesn't know this, but he's somebody that is in our group that we're initially looking at, and we're a little bit ready to go on him, at least partly. So next. We realized that at some point those individuals will need counsel. I was talking to the head of our public defender's office in Ramsey County, and he said, yeah, when you guys reach out, people are not going to believe it's really you or that what you're saying is for real. So they're going to need a lawyer. They're going to need a lawyer to talk through whether they should sign releases and come up with entry plans and reentry plans and just do other advocacy. So we reached out to our local public defender's office, our state public defender's office, some law school clinics, and some other defense firms that do this kind of work. Everybody is willing to help. So our intention is to put together a resource list. And when the individuals who are under consideration get to that point where it seems like they should have counsel, we can provide that resource list, let them, select the counsel that they choose. Next. And then I wanted to take a few minutes because we have really spent some time considering victims in this process and how can we best serve them and be mindful of them. And recently we had an experience resentencing a case that was resentenced for a different reason than this new statute. It was done in part because of a law change and in part because of a change in some circumstances. But it was an older homicide case. It was several decades old. And it involved, we wanted to reach out to three different sectors of the victim's family. And it was really a moving experience and one that has really helped informed us about how we will go forward in our prosecutor initiated cases. So one experience that we had was that we had set up a meeting with the fiance of one of the victims who was killed. And the purpose of the meeting was simply to talk about the change in the law. He knew, and we had made very clear, we were not going to talk about the facts of the case. We were just going to talk about the change in the law. And when he arrived at the meeting, he was a very gentle person, but he was so agitated that he was literally pacing the room in a really hurried and distracted manner. And you could, his trauma was just palpable. And so we ended up asking him if he'd like to set the meeting aside for the day and meet on a different day. And he was a lovely person, very willing to do that. We met a second time and met just to talk about the change in the law. And then we met several other times with them to talk about what we were proposing should happen. the sister of one of the deceased and the deceased mother were still alive. And when we called the sister, she was exhausted, and she said, I had found a peace to cope with this, and I don't want this in my life right now. I've gone through a period of homelessness. I just I don't want to know about this, but I can't leave my mother going through it by herself. So you could just see how stressful and exhausting this was for her. And so those are things that have really stuck with us as we have prepared to move forward. Next slide. And our law is clear that we should get input when we're considering a petition, and we should notify victims when we actually serve the petition. But I'd like to suggest some other good practices for working with victims in these cases. So next slide. I think prosecutors should be reaching out to victims as soon as an individual seems to meet the criteria for resentencing and is under some pretty serious consideration. It's a balance, right? But we know that once an individual can tell they're being considered, they're going to be excited and hopeful. They're going to be telling other people in prison. They're going to be telling their family and friends. It's a small world out there, and it won't take long before word gets back to victims. And we want to be sure that the first notice of this comes from us, that we are the first ones to reach out to victims. So we need to balance doing that with not alerting victim to something that is too far away and not likely to happen. But once you get a sense that yes, this is going to, we are going to pursue this and consider this, I think it's important to start reaching out. I think it's important to have several meetings with the victims, not just for explaining a change in the law, but also because we've all had experiences of the minute you hang up the phone is when you think of your best question, or the minute you leave a meeting, you get in the car and think, why didn't I ask X, Y, and Z? So we want to make sure that victims have a chance to do that too. We know how they think about offenses might vary from day to day, depending on how they're feeling. And we want to give them time to absorb the information, ask questions, come back and ask again. So our goal is to really make sure that the victims never have a sense that they're the last to be brought into the conversation, and that we have several really meaningful conversations with them about it. Um, of course, avoid, the birthdays of the victims, anniversaries of the offense. When we did notification in our Felony Murder Reform Act, we were really careful to avoid notifying near the holidays, just trying to cause as least harm and triggering as possible, but also realizing that this is going to be triggering and painful. Um, I'm a great believer and supporter in restorative justice. In the case that I was telling you about, we did work with our Department of Corrections, and they were able to offer some restorative justice possibilities for the families. But that it for as helpful and as important as restorative justice is, it doesn't fix how people are feeling about this. And I think it's important for us to own that and know it, and consider that as we move forward. Next slide.
5-minute warning.
Thank you. And so we also know, as we get ready to do this, how important it is for the individual to have a really specific, solid plan for reentry in place. It's one thing to be able to bring these petitions for resentencing, but we know that it's going to be another thing to convince a court to do it. So that showing the court that there's a good plan for this person is really key. And we've reached out to different law clinics and organizations that do reentry work, so that they're available to help defense attorneys who are representing people as they carry on.